Good afternoon, guys. Aaron Dorr here with a major update for gun owners. We are live on the ground right now today here in East St. Louis, Illinois, in federal court over J.B. Pritzker's recently enacted ban on the AR-15 and 150 other specifically named firearms. East St. Louis is not exactly a very fun or very safe place to be. If you've ever been through here, you know what I'm talking about. We had to pull away a few blocks away from the courthouse just to get a good safe spot, hopefully, to shoot this video. But guys, we're here because this is ground zero right now in the fight to overturn the idea of the assault weapons ban, the AR-15 ban that is is currently in place in about a dozen states across the country. The backdrop here is pretty simple. Governor Pritzker enacted this ban in January of last year. It happened very early in 2023, and there was immediately, as you can imagine, 6 or 7 different lawsuits filed against this law in federal court. Our organization joined in those lawsuits via an amicus brief because we know that the fastest way for us to safeguard freedom here is to get the Supreme Court to rule on the idea of an assault weapons ban anywhere in America. And right now, there are 2 cases that are the closest to being heard by the United States Supreme Court. One is the case right now here in Illinois, and one is the Bianchi case in Maryland. And so we're involved in these cases because this is how we secure freedom in our state. So the mechanical backdrop here in Illinois is somewhat complex. When the initial cases were filed, they were more or less bundled into one main case. That case was heard by Judge Stephen McGlynn. He is a Trump-appointed judge who was actually the judge we're before right now today here in East St. Louis. He found in favor of the pro-gun side and said this law is unconstitutional, and he put a stay or a pause on the enforcement of it. That then was appealed by the state of Illinois to the circuit court in Chicago, the 7th Circuit, and they asked, and the court agreed to override Judge McGlynn, and they removed his stay on the enforcement of the law. Their decision, their opinion, was perhaps the worst that we've ever read when it comes to the legal fight to defend the Second Amendment. The 7th Circuit actually believes that this is not a gun case because in their minds, AR-15s are weapons of war. They, therefore, are not protected by the Second Amendment in the way that a standard hunting shotgun would be. It was madness. It was total tyranny. And so then we appealed to the United States Supreme Court, and we asked Clarence Thomas to give relief to gun owners here in Illinois. Clarence Thomas and Alito both said they would love to take the case. The problem is the rest of the court said we will not hear this case until it has first actually been argued on its merits at the trial court level. In other words, we were asking for a preliminary injunction. What the court said is you have to have your actual day in court on the merits of the case first, then go through the appellate process, then come back to us and ask us to weigh in on this case. That's where we are in the process today. Judge McGlynn, again, he's a Trump-appointed pro-gun judge. If he sides with us in this case, and I think that he probably will, Illinois will immediately again appeal to the circuit court level and ask them to block Judge McGinn's decision. On the other hand, if somehow he goes the opposite direction and he finds against us, then we'll appeal to circuit court. Either way, whoever loses at the end of this bench trial here in East St. Louis will appeal to circuit court, and that's what we need. We have got to get past district court, where we are today, circuit court, where we're going to go on the appellate process, and then the case can be heard by the United States Supreme Court. That is why we are here. The fastest way for us to safeguard freedom in our state is to have the Supreme Court rule on one of these so-called assault weapons ban cases and give clarity to this issue across the country. Again, there's 2 paths right now on this. One is the Bianchi case in Maryland, and one is the case, it's Caleb Barnett, if you're curious. Caleb Barnett versus Raoul, who was the Attorney General here in Illinois. These are the 2 cases right now that are the farthest in the system in the federal court system right now to being heard by the United States Supreme Court. So guys, thank you for all of your support. It was your support that allowed us to file our amicus briefs in this case. It was your support that allowed us to ask the Supreme Court to weigh in on this case. And we're still here because of your support. Thank you very much, guys. Much more to come. It's going to be a 5-day trial. We'll have more updates for you as the week goes along. To get more involved today, follow us on social media. We'll keep you guys informed.